Howdy, and welcome to the show. Cooper's Code examines a legal issue and hits the highlights so we can all achieve the best results for our clients. I'm Miles Cooper, and with today's guest, Carole Okolowicz, we will be discussing the strategy, art, and irritation inherent to deposition objections. Before we get into today's topic, a few words about Cooper's LLP. We at Cooper's are committed to thought leadership, developing the best talent, and honing skills through learning, practice, trial, and the relentless pursuit of justice for consumers. With lawyers licensed in California, Oregon, and Washington, we're available for free strategic consultation on cases, and we accept referrals and trial co-counsel opportunities. For more information, visit our website at coopers.law or email us at podcast@coopers.law. Carole, welcome to the show.
Thanks, Miles.
So today we're talking about deposition objections. I presume you've been to more than a handful of depositions where what's going on with the opposing counsel may be less than enjoyable.
Yeah.
Most people outside of those who are doing this kind of work on a day-to-day basis might see objections as binary, either object or don't object. What kind of challenges do you face internally when evaluating whether you should or shouldn't object in the moment in a deposition?
When I'm making this decision whether or not to object, there's a lot that's going through my head in that moment. Can I is the first one. Should I is the next one. And then it goes back around to, can I? I mean, I'm 5 years in as a lawyer. So I'm still kind of like, can I make an objection? Is that a valid objection? I've definitely made more than a few objections that were not valid that I made, I guess, partially to interrupt the flow of the questioning. I didn't like what was going on. It was my client was being deposed. So can I was a no, but I went ahead and did it anyway. But I've definitely gotten hung up on the can I question, where I'm searching through my internal files of depo objections, and then I've missed my chance because my client jumped in and answered anyway. Should I is partly, do I want to highlight this issue? Is it better to just let it go and not show that I'm concerned about it at all? I had a case where a client hired somebody who was undocumented to care for them after an accident. And there was a question at my client's deposition about something related to that. And I thought, what do I do? Like, can I object? Do I even want to bring an attention or focus to this? Maybe it won't even come out. And all of that, like we say, is in a split second. You have to make that decision. So I guess that's what's going through my mind in a deposition.
You say you're 5 years out. I'm, I think, 23 years out at this point. I still have the same problem. That can I, should I, and the strategy behind whether you object ties you up almost more than the objection itself.
Right, yeah.
And one of the things I feel that I've learned from watching other lawyers, working with really good other lawyers, is if your gut is telling you that you should object, object.
Yeah.
Even if you're not even sure what the objection is or whether you should, there's nothing wrong with going ahead and putting it out there, because if you don't, you have the opposite problem, which is thinking about whether I should object, that the information comes out and it's like, oh yeah, I shoulda.
Yeah, right. At least you got it out there, yeah.
The other piece, and I kind of started off on the objection piece, in our role, most of the time, our objections are going to be related to our clients and perhaps treating doctors and experts, but generally, they're people who we can have an opportunity to work with before we get to deposition. And one of my feelings on objections is the best way to be great at objections is to have the right client or witness session before the deposition to make sure that you know what information is going to come out. And I will tell my clients typically, I don't object much. And the reason I don't object much is because we've gone over what we're going to go over. If they're completely out of line, I am going to object and I'm going to instruct you not to answer. If you're getting an objection and it's not an instruction not to answer, if I'm telling you vague and ambiguous or some other thing, you're still going to answer to that question. But it's a telegraph to you that, hey, look, I don't understand that question. You might need to think about it.
Yeah. Sometimes I think that can help a client in deposition. You're not leading, you're not telling the client what to say, but a client can get nervous sometimes. And you can sense that. And let's say a question is vague, but, otherwise you would think somebody could probably answer that. If you got a particular client who you're sensing is just nervous about the whole process and scared, and I'll object and say it's vague. And then, like I would with any client, go ahead and answer if you can. And sometimes a client is looking for support. And so maybe they'll see that and go, okay, I don't just have to scramble and try to figure out an answer. Like we talked about in depo prep, I'll ask the person questioning me to ask it a different way or something.
As we talk about this, I always worry about the vague objection. In one sense, I like it to help, telegraph to a client, hey, this question's a little off. At the same time, if the question is truly vague, it's the defense lawyer's job to get a good record, not our job to fix their questions. And so on a vague question, if they've left it vague, unclear, they're not going to be able to box our client in at trial. You always want to highlight the vague question.
It depends. A vague question could mean that my client is answering that she had the same injury before the accident as she has after. And a vague objection might be, I don't understand what you're asking. Can you frame it? Whatever. I'm not going to say a vague as to time frame. No, that's not true. I have, definitely. Can you clarify what time frame you're asking about? And sometimes the defense counsel will chop it up. Okay, did you have this injury or whatever before the accident? Did you have the injury after the accident? It's not so much that I want to help the defense attorney, but I want to make sure my client's not testifying to something that then the defense attorney can use later on.
That makes a lot of sense. The other area where I probably find more frustration is when I'm dealing with opposing counsel who is objection heavy. Have you had that experience?
Not that much, but yeah, I definitely have.
When I say objection heavy, I mean either they're objecting with speaking objections, which is in essence telling their client what to say. Objection, you've already testified that you did da 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 da.
Right.
Have you had the speaking objection problem?
A little bit, not much. I've had the over objecting problem more with not defense counsel, but I don't know why, but it happens in cases where I'm deposing a doctor, and for some reason it's always a Stanford doctor.
There's a reason for this.
I'm sure there is. Why I have to go through their counsel to even talk to one of their doctors. They're very protective of their doctors.
Well, this is a tangent. I think it's an important tangent to cover. And it's Stanford, UCSF, sometimes Kaiser, sometimes some of the other Palo Alto Medical Foundation. The E&O carriers for those doctors give them a free lawyer for deposition. And not only do they give them a free lawyer, they say, you cannot talk to the plaintiff's lawyer or the defense lawyer in advance. You can't have a prep session with the treating doctor, which is why you have this usually junior lawyer, not great, who feels it is their job to do textbook objecting throughout the deposition.
Okay, that comports with my experience. This doctor is not on trial. We're not suing this doctor. I just want to know.
My understanding of the reason behind this is it's from the risk assessment, the risk management department. It's worth it to pay all of this to make sure that there's not some inadvertent, oops, doctor testified to something where now they've been brought in as a malpractice defendant peripheral to an injury case, as I get heated on this. The issue I find in this is a lot of doctors don't review their file beforehand. And the prep session with the doctor is not to tell the doctor what to say.
Yeah.
It's so you're reminding the doctor, yes, my client was Tom Jones. This is his file. These are the things you did to him. Do you remember this piece? Oh, yes, now I do. Okay, well, we're going to have some questions about this particular component of it. Are you all booted up on that? And the number of dead-end depositions I have because of this, in addition to the objecting. But yeah, there you go.
Yeah.
End of diatribe.
Right. Okay.
Going back to the objections, so you've run into some of these speaking objections with these junior lawyers who are there to try and fence off the doctor.
Right. Yeah.
How do you address them?
I just call it out, put it on the record that it's a speaking objection. And then I tell the deponent, you can answer the question, and then try to ask questions around it to try to deal with it.
When you're in that setting, have you ever adjourned a deposition to take the lawyer out and say, hey, I don't want to embarrass you, but what you're doing is completely improper in terms of the speaking objections, and I'm taking you out of the room so that we're not getting into an ego fight about it. But if it persists, I'll be forced to have to do something like a motion to compel or a motion for a protective order, none of which you want to do from a billing perspective. But I'm doing this outside the presence because I don't want to embarrass you in front of other folks. Can we tone it down?
It's so funny because two things came up for me when you told that. One, no, that's never happened with me. It's never been that bad. And two, I've taken now, or not taken, actually both times defended, 2 in-person depots in my whole legal career. Everything else has been on Zoom because sandwiched in between everything was the pandemic. So I don't even know how I would. I guess I'd just pause it and call the guy.
Yeah, it's interesting.
Yeah. It's a different dynamic when you're physically there in person. A couple days ago, I did an in-person deposition, and it was my first before the pandemic. And it was like, oh, somebody handing somebody a physical, photograph for an exhibit. It just was very foreign.
At the risk of tangenting, there are pros and cons on that Zoom depot process. The fact that you can get through a lot more work without spending all that time in transit is nice. At the same time, the ability to have that personal connection and try and realign something without embarrassing them is much harder.
Sure, yeah.
Going back to the attorney who objects a lot, are there ways that you are able to either wall off that lawyer or do things to make sure that you are maintaining contact with the witness as opposed to getting sucked up into the fight with the lawyer?
Yeah, again, I'm newish at this and I just ignore it. I pretend like nothing ever happened and I just say, you can answer. And sometimes the deponent will take a cue and say, yeah, I really don't understand your question, or whatever. Depends on the situation, of course, but, well, I was just asking this. And then I say the same thing again. Or I clarify. I'm trying to get the information. I'm not trying to fight with anyone.
We talked a little bit about taking somebody outside or talking about the need to bring a protective order. In the back and forth that goes on in a deposition room, one doesn't have the benefit of having a judge right there. And from a plaintiff perspective, while we will do what is necessary to prevail in a case, there is that inherent challenge in recessing to seek a protective order that's a slowdown in the case, and that is not a guaranteed outcome. What calculation do you do as you think about the difficult behavior of the defense counsel versus the risks, challenges, delays inherent to seeking a protective order?
Well, of course, it depends on the issue. How important is it in the case? If it's my client being deposed, I want my client to know that they're protected. So if what the defendant is doing is trying to do some kind of character assassination that's not relevant, I think it's worth it to just end the depot if that's what's going on, because I want to make sure that they're not just playing games with my client.
As you evaluate the risks, benefits of suspending a deposition when somebody is being challenging, do you consider some of the challenges that go along with stepping into law in motion? Let me put some meat on those bones as far as the direction of the question. We know when a case is in federal, a federal judge is much more likely to sanction or smack people around. We know in state court, the law in motion sometimes can be a month's delay to get into law in motion. And frequently it is you kindergartners, you're both responsible for this. You go work it out. Sanctions rarely happen. With that as kind of a backdrop on addressing the issue, how do you navigate that as you reach a point where you think about it may be time that I actually have to pull the trigger? And because I can't ask a simple, straightforward question without it being super long, do you sometimes consider taking your client out to explain, okay, this is going on, it's not okay, let me explain how the court system works in terms of law in motion. If we suspend right now, it's going to be a 2-month delay and we'll be back here, or we can get through it. Guy's a jerk and we'll just kind of absorb it and move through it. It's not okay, but the delay is just not worth it.
Again, everything depends on the situation. Is it important enough to delay the case for a month? Your opposing counsel's attitude in doing that, in whatever that person's doing, is I'm going to throw my body on the tracks. I don't care if I stop it, because, he's trying to push the case around or whatever. It may be worth it to push back just as hard. If the delay harms your case and your client, you're proposing a real crappy situation here. And that is, your opposing counsel is such a jerk, but you really can't fight what they're doing without negatively affecting your own case and your own client. It's a tough call. It's got to be pretty important. If you know that's how it's been going in the law and motion department, if you are pretty certain that it would be a month delay, then yeah, you just have to assess it on what you know.
I find this topic interesting, and part of the reason I find it interesting is I do everything in my power to, I will describe it as collaborate with the other side. And by collaborate, I mean, it's my job to get them the stuff so they understand the risk so they can get the money.
Right.
At the same time, it will, in that vein, moving to compel, doing all the law and motion fights tend to not advance the ball from my perspective, with exceptions. And those exceptions are sometimes you have somebody who is so used to throwing their weight around and so obvious in the way that they do it that they need to be checked. And once you check them, the trajectory of the case changes. But until you check them, it will just keep going.
Yeah. I don't know if the courts have changed in this respect over time. I know that there is a lot of talk about civility. I know during the Trump presidency, there was a lot of talk about civility because there just was a lot of incivility in public office, and people with positions of importance in our civil society were acting uncivil. And there was talk within the legal profession about, well, at least we can stand up and be stand-up folks and get along and get things done and still do our job, still advocate. And I don't know if that translated into the courts taking civility a little bit more seriously. Again, in any given situation, you want to assess, if I put this in front of the judge, is the judge going to roll their eyes? Is this important enough? But I've seen ethics cases where the court did take civility serious and took the time and reprimanded counsel. So I don't know. It's just a decision-making process.
For some reason, you make me think of the rock, paper, scissors order, which is floating around out there where the arguments were so intense in the case that they couldn't agree on where the deposition was going to take place. And the judge ordered them to go out and play rock, paper, scissors on the front stairs of the courthouse.
Nice.
There are particular concerns when a deposition is being videotaped as it relates to objections. And by that, I mean making sure that the objection is not getting in the way of the answer. While a court reporter can take down only one person at a time, they usually are able to parse it when it's on the transcript. But when it's on the video and the attorney is talking over at the same time that the answer occurs, how do you address that when you're trying to keep your record clear?
Re-ask the question. So if there's a lot of overlap, just say the same thing over again. Maybe slower so that everybody knows what you're doing. So you've got a clean record.
That I've heard that from other lawyers, that a counsel, this is being videotaped. We're videotaping it because we intend to play it to the jury. And I accept your objection. I accept a standing objection on that for this next section. And I'm going to repeat my question. And when the lawyer does it again, because there are lawyers who will say, yeah, I understand all that, but I'm still going to get in your way.
Yeah.
The fourth time you repeat the exact same question is about the time that they stop doing it. But it is a real challenge.
Yeah.
And I think that if you put on your movie director lens to recognize that the jury needs to see it not because the objections are supposed to be edited out typically for trial. And so if you put your movie director lens on to see how this is going to come across and then make sure that you go back and re-ask the question, I think that's important.
Yeah, probably the best way to get a clear record for trial.
With all of it being covered, Carole, thank you for being on the show.
Thank you for inviting me.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for how you handle objections at depositions. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.